if you can't hear me during it, let me know.
All right, I think we are now live. Thanks everybody for tuning in. My name is BJ Kilgore. I am an attorney in the Trust and Estates practice group here at the Winkle Law Firm. I'm joined by Melody King, who is also an attorney in the Trust and Estates group here and also practices in the area of family law and divorce. This is the fifth, I believe, in a series of 16 different Facebook Live discussions that we are having on a variety of issues, ranging from estate planning, estate and trust administration, various types of trust, tax planning, powers of attorneys, and other related issues. Today, our topic is on the intersection of estate planning and divorce, and they do cross over in a lot of areas. And Melody has come up with the creative or depressing title, however you want to look at it, of Till Death or Divorce Do Us Part. So we're talking death and divorce today. We have structurally basically divided this up into 5 different segments to try to make things easier. The first is a consideration of issues surrounding items prior to the date of marriage, so before you actually enter the marriage. Then a discussion about things that you should be aware of while married, but before separation, so theoretically at a time while the marriage is stable. The third is going to be a discussion about items to consider during the midst of a separation or a divorce. And then finally, post-divorce considerations. And then really the fifth part of this is going to be answering some questions that may come in during this Facebook Live process, or frequently asked questions that Melody and I receive. So without much else, I will hand it over to Melody to dive into our first topic, which is things that need to be considered prior to entering the marriage.
Yes, thank you, BJ. So first I'm going to go over just exactly how property is described in a family law context, because I think you need to know that before you can understand how it's divided. So separate property in a family law context is property that you came into the marriage with. So that could be a house, bank accounts, money, personal property, your stuff, anything like that is your separate property. And also during the marriage, if you get an inheritance or a gift that was intended to be just for you and not a gift to the marriage, that will be your separate property, even if you get that during the marriage. Marital property is anything that you get, aside from what I just said, anything that you accumulate during the marriage, any assets that you accumulate. This would include, real property, your paycheck, your income. This will be considered marital property. Even if you take your income and you put it in a separate bank account with only your name on it, that's still marital property and subject to division upon divorce. If you take a house that you had prior to the marriage, or if you have a parent that's going to gift you a house during the marriage and you title it jointly between the two of you when you are married as tenants by the entirety, that is presumed to be a gift to the marriage. And that's a pretty hard presumption to overcome, to show that it was intended to be separate property. And then you can create a mixed asset. This is a different kind of asset. So for example, if you were to come in with a bank account with $50,000 in it, and you contribute your paycheck, that you earned during the marriage, if you contribute that to the account, now you've created a mixed asset. Likewise, and then the mixed asset, the part that you didn't come into the marriage with, that would be subject to division pursuant to a divorce. Likewise, I also see, if you come in with a piece of property that's separate property, you don't change the title, that remains your separate property. But then if you take your income that you make during the marriage and you build onto that property, or you put a new deck on or whatever, now you've created a mixed asset, and the part that you contributed during the marriage would be a mixed asset subject to distribution pursuant to a divorce. So how do you, now that you kind of see how property, how it fits into the family law perspective, how do you get around that? How do you contract around the default rules? And you can do it really by a prenup before the marriage. And this is a contract, a private contract between both parties with the intent to marry, and it needs to be in writing, it needs to be signed. We recommend that it be notarized, and there's certain provisions that if you were to get divorced through equitable distribution, there's reasons to have it notarized. And you have to have full and fair financial disclosure. It doesn't have to be down to the penny, but depending on the case and depending on how many assets you have, you need to get it pretty close. You can't hide a bank account out there with a significant amount of money in it and expect that your spouse has waived interest in that. So reasons why you would want a premarital agreement, there's several, and it really needs to be tailored to your situation, what you're coming into the relationship, to the marriage with. A few things to consider: if you have a family business and you are not just an employee of that family business, but you're an actual owner, and you have that prior to the marriage and you're coming into the marriage with it, you are probably someone who wants a prenup, because you're working on that business during the marriage and you have this marriage and you're growing the business and making it more valuable. The part of the business that you grow due to active efforts during the marriage, that part would be subject to equitable distribution upon divorce. Now, if it was just passive appreciation, meaning you didn't really do anything, you didn't help the business grow, then that would remain your separate property. But usually you're going to actively appreciate the business. Another example is if you have a house prior to the marriage, you own a home, it's in your name, or you inherited it from your family, or you inherited money and you bought the house. Once you get married, if you update the house or you make improvements or you build an addition, anything like that, you're putting your income into that house. Now you've converted it into a mixed asset, and the part that you've actively appreciated the house, or the amount that you've actively appreciated the house, that would be subject to division upon divorce. And another reason, these are just kind of the big ones. Inheritance, yes, if you receive an inheritance during the marriage, that's separate. But if you want to take it and commingle it, you just run the risk of mismanaging it and commingling it and creating a marital asset. If you want to buy something during the marriage, or if you want to just mix it in with another asset, now you've created a problem. And then the other one that I see a lot of times people wanting to protect is their retirement. This is a big one. This is becoming more and more popular. People just want to protect their retirement because it takes so much money to retire nowadays. And if you accumulate all your retirement while you're married, and you divorce later in life, you don't have as much time to make up what you've lost, and you could be in a totally different position of retirement than you were set up for otherwise. Let me see what else. And there's a lot of I get asked a lot of questions when I tell people that I do prenups. Doesn't that just make it easy for people to get divorced? Things like that. And it doesn't. I mean, but you can focus, instead of focusing on the financial aspect, if you do eventually want to get a divorce, you can focus on the emotional aspect. Is this right for me? Is it not? And you don't have to deal with the financial aspect. You already know. So you don't want to be in a position where you can't get divorced, or you feel like you can't leave a situation because you can't afford it. or because you thought that this property was your property, but it's really a marital property and you're going to lose half. Or, you know, I had this house, but now there's going to be a sale forced because I can't buy out my spouse's marital interest, even though it was my property to begin with. So it just takes care of that, and they can be premarital agreements can be as detailed. They can be very specific. You can just deal, with retirement accounts and leave everything else the way it would go pursuant to if you didn't have a premarital agreement. Which if you don't have a premarital agreement, the default in North Carolina is that the marital assets will be divided 50-50. And there is a statute that allows for an unequal distribution, but from what I've seen, at least in Buncombe County, you're not looking at, a 60-40 split. It's still pretty close to 50-50, but you might have some wiggle room there, but it's not a lot. And I don't know how that plays out in Charlotte and other areas. But, marriage is many things, but it is a business contract. And, the premarital agreement allows you to write your own business contract. If you don't have a premarital agreement, you're still in a business contract. It's just that the laws of North Carolina have written it for you instead of you choosing what's best for you. And like I said, we can do all kinds of things. You can do, everyone keeps their own retirement account, or I drafted one recently where, husband came in to the marriage with a business. He wanted the business, and wife wanted the marital home without any buyout. And that's fine. That's something we did for them. It just really depends on your circumstance. Let me see what else.
So
Another, yeah.
Oh, I was just going to ask to cover real briefly just some of the impact of how a prenuptial agreement could assist people who have goals to ensure that their assets might pass to somebody other than their spouse, and how spousal rights interplay with one of those agreements.
Yes. So you have family laws, and then you have estate planning, estate administration laws, and they don't always line up perfectly. So without a prenup or a postnup, which BJ will get into, you cannot fully disinherit your spouse in North Carolina. They are entitled to automatically, if you were to pass away, they would be entitled to a year's allowance right off the top of your estate. And this isn't just the marital estate, this is their estate, your estate. And I believe that's $60,000, right, BJ? Yeah, so they would, your spouse would be entitled to that right off the top. There's also a thing called elective share in North Carolina, which basically gives your spouse a certain percentage of the estate, and that depends on how long you've been married. So less than 5 years is 15%, between 5 and 10 is 25%, 10 to 15 is 33%, and more than 15 years is 50%. And that there's no judicial discretion in that. It's not like a family law case where there's a little bit of wiggle room. That is pretty much guaranteed to your spouse. So if you have an issue such as a blended family, and what I mean by that is you have children, one of you are bringing children into the relationship from another relationship or marriage, you might want to leave more or everything to that child. If your spouse is, well off, or you're going to leave assets for your spouse in a trust or a life insurance policy or something like that, you might want your actual estate to go to your kids. And in order to waive all the rights that your spouse has by virtue of being married to you under the estate planning laws, you have to include that in a prenup or a postnup. And the benefit of doing it in prenup is that once you're married, your spouse does not have to agree to a postnup later on. And another consideration, and you can also actually waive if you were to separate, so you get married, you separate, North Carolina has a 1-year separation period before you can actually get your divorce judgment. And estate planning laws do not recognize the difference between married, separated, and divorced. They only recognize you're either married or you're divorced. So in the meantime, during that 1 year, a lot of times you will see parties enter into separation agreements. They're very common, and a separation agreement can have the waiver language in there to waive all those spousal rights. But again, your spouse does not have to sign a separation agreement. And if you happen to pass away during that time, they will get the rights to your estate. There is a small provision if there was an abandonment issue, which is not just separating, and it's a few other situations where that might not be the case, but you're going to have to litigate it. And the whole point of this is to avoid litigation, which is another benefit of a premarital agreement. Litigation is extremely expensive, and my clients that come in that want a divorce that have a premarital agreement, they're pretty much set. And if they haven't touched an issue in the premarital agreement, then we just have to litigate that one issue or try to work it out, and that's much cheaper than having to litigate a whole equitable distribution case. Is there anything that I missed, BJ?
No, so I'll sort of transition it from there, and so that's some of the items, prenup in particular, to consider prior to the date of marriage. So after the date of marriage, things have changed a little bit, but transitioning into that, there's still some things that you need to be aware of and consider at that point. And so really, I think what you'll see here is that there's kind of, from an estate planning perspective, some competing interest at play. On one hand, while you're married, you have the option of using some pretty simple, straightforward, effective, efficient estate planning tools in order to pass property from one spouse to another. I'm thinking of things like owning a bank account jointly with the right of survivorship, or an investment account with the right of survivorship, naming your spouse outright as a beneficiary on life insurance or a retirement account like a 401k. There could be some real benefits of doing that. Naming your spouse outright as the beneficiary of your will or your revocable trust. Some benefits of doing that as well. And owning real estate together as what's called tenants by the entirety in North Carolina. There can be some particular benefits of that, including the survivorship component, but also creditor protection. In addition, while you're married, you also kind of open up the world to some other advanced, maybe more advanced planning options that, depending on your circumstances, might be justified. Things like perhaps the splitting of your wealth equally in order to try to minimize eventual estate taxes, or the creation of an irrevocable trust that might have your spouse named as a trustee or as a beneficiary, or even instead of using separate revocable trust as a substitute for a will, you might create a joint revocable trust. Those are all options that could be available depending on your circumstances and may be very justified. So you've got those on one hand, and on the other hand, you do have to keep in mind and be careful that after you become married, if you did have some of those asset protection goals, and let's say you had a prenuptial agreement in place, you want to be careful that the steps you're taking after the date of marriage don't completely disrupt or make your prenuptial agreement ineffective. A good example of that would be you're from a blended family. You enter into a marriage, each spouse has children from a prior relationship on both sides, and one of the spouses has let's say an investment account that they have earmarked to go to their own children. It's in after the date of marriage, what that spouse does is take it because it's easy, and maybe they just wanted their other spouse to have the ability to sign checks on their behalf. They take that account, which was separate, and make it a joint account with a right of survivorship. Pretty straightforward, pretty easy to do. The problem is you may have just disrupted your entire estate plan by doing so, because as a result, that account will then pass to the surviving spouse. So, part of this is identifying your goals prior to the marriage, putting a plan in place prior to the marriage, and then after the date of marriage, making sure that you are careful and intentional about the actions that you do take to ensure that, whatever those actions are, they're consistent with the plan, or at the very least, not inconsistent with the plan that you put in place. But first and foremost, after the date of marriage, the first thing that should be on your mind is really just updating your estate planning documents. Your will, your power of attorney, healthcare documents as well. And that could be as simple as just updating those to name your spouse as a beneficiary or as somebody in a fiduciary role, like your executor or your agent acting under one of those powers of attorney. The other things you might want to do in updating those documents is consider whether they need to be updated so that they are consistent with the terms of a prenuptial agreement if one is in place, or with your asset protection goals. An example there would be, let's say that you've got a blended family again, and I hate to harp on that example, but it's easy. And one spouse owns the marital residence. And ultimately, that spouse wants that property to pass down to his or her children, but they don't want to throw the other spouse out on the street if he or she passes away. And so oftentimes what someone might say in a prenuptial agreement is, when I die, I want my spouse to be able to reside in the marital residence for a period of years or for their lifetime. And that's great. But you do want to make sure that your estate planning document reflects that as well, so that you've got some consistency among these documents and at least not inconsistent. So that's an important thing to look at after the date of marriage. You probably also want to name some backups to your spouse, just in case of a divorce. Certainly a divorce, as Melody will talk about, usually will cut off the right of your spouse to serve as your executor or your power of attorney. That's great, but you probably want to have someone named as a backup just in case. And then, the other items here are updating your retirement account and your life insurance beneficiary designations to make sure that they are now consistent with your new situation. And also, alluded to this a little bit earlier, but consider whether you are going to continue to own your property or your accounts in your individual name, or whether you do need or want to take advantage of some of the components of joint ownership, meaning moving your bank accounts into a joint account, owning real estate jointly and taking advantage of that. Could be some real benefit to that, but there could also be some real downfalls if you're not careful. The other thing that I think bears some consideration in terms of after the date of marriage discussion is a postnuptial agreement. And I won't go into too much detail on that because Melody talked about a prenuptial agreement, which is very similar. Postnuptial agreement is much less common. And the situation that arises is when a client comes into the office after having been married and they express some goals related to making sure that their assets or their property is preserved for their children or another beneficiary instead of just their spouse. Or they want to establish what the rights and obligations are between the spouses upon death or divorce. In that scenario, after the date of marriage, a postnuptial agreement may very well be an option. Again, a postnuptial agreement has just about all the same requirements as a prenup does. Big difference is it's entered into after the date of marriage, before the parties are contemplating a separation. So it's different than a separation agreement in that regard. But really what it can do is establish how property is to be divided upon death or divorce, potentially waive spousal rights in an estate, and kind of set the parameters on things like that. What it cannot do is establish alimony or waive alimony or spousal support. Also can't establish child custody or child support. That has to be saved for after a separation in the separation agreement or divorce court order. But long story short, depending on your circumstances, a postnuptial agreement might be very helpful, and you haven't completely lost the ability to control some of those things after the date of marriage. So with that, I will really pass it back to Melody to talk about some of the items you need to be aware of during the midst of a separation or divorce and then I'll talk very briefly about post-divorce considerations.
Sure. And I do want to mention, kind of follow up on what you just said about you can't waive alimony in a postnup under North Carolina law. You can waive alimony in a prenup. And you want to be careful when you do that, and you do want to, in a prenup, and you do want to think about your situation. If you are planning on having a family and you want to be a stay-at-home parent, you probably don't want to waive alimony in a premarital agreement. So you do want to be careful about, what you are giving up or getting in a premarital agreement. So, and I do want to mention, I didn't mention this before, but this is a big one, especially for anyone in my generation. You are a product probably of student loans. And the way that works in a family law context is if you are married and you accumulate student loans, the part of those loans that went to tuition and things like that are the person's separate property, separate debt. But if you took out loans and you also paid for living expenses, rent, food, whatever, and you're married, that is a marital debt. So you want to think about that, and you can contract around that in a premarital agreement. So I realize I'm almost out of time. So really quickly, like I said, estate planning they don't recognize really the difference between separated and divorce, and you have the 1-year waiting period. So what does that mean? On different estate planning documents. So the will, if you're separated and you have a will all to my spouse or whatever to my spouse in the will, and you're separated, that there's no impact on that divides in the will. Once you are divorced, then whatever you had in your will that your spouse will not get. It severs that right to take under the will. But during the separation period, if something were to happen to you, it's likely that your spouse is going to take under whatever you gave them under your will. What's the next? The one thing that I will say that doesn't change is your designation on your life insurance policies. You need to update those. You don't want to, that does not sever after you get divorced. So if you have a life insurance policy, you've named your spouse and you never changed it, and you've been divorced for 20 years, and you pass away, your spouse is going to get that life insurance policy. For a power of attorney, this is a general power of attorney over financial matters. The separation will not revoke that power of attorney unless the power of attorney provides otherwise. But your agent's authority, your spouse's authority to act will terminate when you get the divorce. And the same with healthcare power of attorneys. It will not terminate. Separation will not have an automatic impact on that until divorce. But I will say that if you do a separation agreement, which you can only do if you are actually separated, you can waive, your spouse's right to make healthcare decisions and all that in a separation agreement. But a lot of times you can't agree, and you can't force your spouse to sign anything. So you do need to be careful and update those documents as soon as possible to protect, what you intend. And I will say too, I believe, BJ, correct me if I'm wrong, but if you have a will that is, I give such and such to my spouse and I give such and such to my spouse's parents, that divorce will revoke the gift to your spouse, but not to your spouse's parents. I believe they will still take. So you really need to be careful to update your entire will plan. I believe I'm correct on that, but maybe not.
Yeah, so I think, kind of to parlay off of that, the post-divorce considerations are pretty simple. It's update your estate planning documents. That's what we would tell to every client. Usually that means removing your ex-spouse as a beneficiary or a fiduciary, even though state law may have already removed them itself. For clarity, good idea to remove them anyway. If you want to, you don't have to necessarily. The other part about that is to make sure that your estate planning documents are now consistent with any type of separation agreement or court order that is put in place related to the divorce. Quick example of that would be a court order in place providing that one spouse pay the other alimony for a period of 10 years. In order to kind of provide some security that that still gets paid in the event that the spouse who's supposed to be paying it dies before that 10-year period expires, oftentimes an agreement or an order of that type will require the estate of the spouse to fulfill that obligation, or that spouse go out and obtain life insurance as security. And so you want to make sure that your plan mirrors the court order, otherwise, or the separation agreement. Otherwise, you might create some unnecessary confusion, which could lead to more extensive cost and maybe even infighting. And then, finally on this, and this is a big one because we see it somewhat frequently, and Melody touched on it, is making sure that you update beneficiary designations to life insurance and to retirement accounts, because the divorce does not cut that off. And I've seen numerous cases where people have been divorced for 5, 10, 15, more than that years, then pass away and have forgotten over time to take their ex-spouse off as the beneficiary of their retirement account or their life insurance. And the end result in many situations, and the likely result, is that that ex-spouse will inherit that money, even though they have been divorced. So that's a huge point to consider and to remember after divorce. I'll leave it at that. We are sort of at the edge of our time limit here, so I don't see any live questions that have come in. If anybody does have questions, feel free to reach out to either of us, or just post them on our Facebook page and we'll try to get back to you as soon as possible. Otherwise, I'll leave it there and just say that, I would encourage everyone to join us again on Thursday at noon for the next in our series here. And appreciate everyone's time. And that's it. Anything to add, Melody?
No, that's it. Thank you for tuning in.
All right. Thanks.